Good evening, everybody. I just missed my introduction. I normally run that little 30-second thing, and I thought I hit the button to go live, and I didn't hit the button properly. So you don't get the 30-second countdown, but that's okay. I hope everybody's doing well and is staying warm. Here in Atlanta, it has been really, really cold this weekend. On Saturday, I think it's going to be 29 is going to be the high, and on Sunday, 33 will be the high. I'm supposed to play in a tennis match on Sunday. Not really looking forward to that. It's really, really cold. We were supposed to have an ice storm last week. We did not. We just had a lot of cold rain. My crazy wife took the dog out for 2 hours in the 34-degree cold rain. Not me. I pretty much stayed inside. I wasn't going to go out. Just did some weights and some working out in the house, but I'm sure where you're at, this polar vortex has really been crazy. So I'm hoping we won't get a whole lot more cold weather. This has really been quite ridiculous. So anyway, that is enough to say about the weather. If we all talk about the weather, nobody can do anything about it. So want to go ahead and kind of jump into the questions if anybody has any specific things. One thing I did want to let you guys know, because I do get questions about this sometimes. Social Security has been really, really slow in processing decisions. Up until today, I had only 2 decisions processed this month, hearing decisions. And I think I tried 14 or 15 cases in December and November, and there's a bunch of them in process. And I had 2 that were finally approved, and then I got 2 more today, which I'm happy for, but it's been really, really slow. So if you have had a hearing, don't be surprised if it takes a while to get the decision out. They're just really slow. Same with the money processing. It's really, really slow. Not sure what's going on with that, but just be patient. I'm hoping that things are starting to loosen up a little bit, because it's really frustrating. I know if you've waited a long time, 2 years for your hearing, and then you think it went well, you want to get that favorable decision. And if you do get a favorable decision, you want to see that money arrive. And it's not really very pleasant when Social Security takes 6 weeks to do what they're supposed to do in a couple of weeks, but that's what we're dealing with. So just wanted you to be aware of that. Okay, so let's go to some questions. Laura in Oregon, questions: when scheduling an ALJ hearing, does SSA go by the file date of the appeal to schedule the hearing of the date of the initial application? My files have been slow due to surgeries and such. And basically she says, if I couldn't work for 2 years due to injuries and surgeries, do they pay out for just the 2 years instead of denying my entire case? Just got denied at recon. Okay, so as far as the hearing itself, when we request a hearing, so you file your application, you're denied at the initial application, usually 8, 9, 10 months, maybe a year. You file an appeal called a request for recon, another year. Again, it's really slow. You get a denial notice, then you request a hearing. And normally we're getting hearings in 6 to 7 months after we file a request for hearing. So the hearing date is going to be a function of when you file the request, when we file the request for a hearing. It has nothing to do with the onset date or your date of application, anything like that. It's when you file the actual request for a hearing. And a second question she's got is, if you couldn't work for 2 years, could they just pay you for the 2 years? They could. That would be called a closed period. So I have situations where somebody filed an application, they didn't work for 2 years, they had to go back to work because they had to eat, and then it turns out they were able to maintain enough work to be at what is called substantial gainful activity level. At that point, we would notify the court that we're asking for a closed period for the time they were out. In theory, a judge could do that as well if the judge felt that your condition had improved and that for 2 years, 2.5 years, you were unable to work. You could get a closed period for that time, and then if you had a surgery, you had some improvement, they could eliminate that and say you regained the function and you're no longer disabled. Pretty rare that happens. I mean, a lot of people, when they have a serious medical problem, I guess in theory, if you had a surgical situation, you had back surgery, you had hip surgery, you could dramatically improve. Doesn't happen that often, but every once in a while. And again, if somebody has gone back to work because either they've improved or because they had to, we will change it to a closed period. And judges like that because they're not obligating Social Security for a long time. But I don't like to offer that. If I sense that it might come up, I'll discuss it with my client in a pre-hearing. Do you want to consider a closed period? Because things have improved, or because you stopped going to the doctor, or because you went back to work. But generally speaking, we're going to argue that the person remains disabled. But yes, it is possible, Laura, that they could go for a closed period, but probably not very likely, but it could happen. Okay, Kevin, when you win SSI and SSD at the same time, you get SSI back pay from the date of your application, and Medicare, because you got 2 years back pay. I'm not sure about the numbers there. That's the new, let's see here. If people don't work, okay. All right, so let me just kind of generally answer this question. If you apply for both SSDI and SSI, it's called a concurrent claim, and you win as of your onset date. Well, first of all, SSI, you only get paid as of the date of application. So if, for example, you said, I became disabled in May of 2025 and you filed in January of 26, the earliest you could be approved for SSI would be January of 26. You only get paid as of your date of application, whereas in an SSDI case, you can go back a year and get paid. So, but let's assume we don't have that problem. Let's assume a person filed an application for benefits, May of 2025, let's say May 3rd of 2025, alleges an onset date of, I don't know, pick a date, May of 2024, and they are approved as of May of 2000, the onset date of May of 2024. Well, what happens is, in that situation, they don't get paid for the first 5 months for SSDI, so they wouldn't get paid for the remainder of May of 24, June, July, August, September, October. They would start getting paid SSDI as of November of 2024. And by the time May of 25 rolls around, when they applied, their SSDI would have kicked in, and it's probably going to be more than the SSI, so it's going to offset SSI. There'll be no SSI. Now, let's change the scenario a little bit. Let's say that the person applied in May of 2025, alleges an onset date of April of 2025, and they get approved for SSD and SSI. In that situation, the SSI, there's no 5-month waiting period, so they would get paid for May, June, July, August, the first 5 full months in September, and then SSDI kicks in after that 5 months. Then they start getting SSI. In that situation, they would get SSI for 5 months or 4 months, depending on the date of filing, and then SSDI kicks in and offsets the SSI. So it is possible to get SSI for the 5-month waiting period, and then the SSDI kicks in. In very rare circumstances, I mean very, very rare, SSDI may be less than the SSI because the earnings were very low. In that situation, in theory, you could collect SSDI up until whatever the amount is, let's say $600 a month, and then your SSI, which is maybe I think $900 or $1,000, you might get $300 or $400 from SSI and $400 or $500 from SSDI, and you collect both ongoing. I've only seen that happen a handful of times in 30-something years, so it's pretty rare. Usually SSDI is higher. So generally speaking, if you're going to get SSI in a case, it'll be during the 5-month waiting period for SSDI. As far as the Medicare, Medicaid, SSI is associated with Medicaid, SSDI with Medicare. And SSDI, you get SSDI or get Medicare 2 years after your first eligibility for payment. Excuse me. I've got to sneeze. Excuse me. Sorry about that. You ever had to sneeze and you can't get the sneeze out? That's what happened to me. So, all right. But anyway, getting back to that, the SSI and SSDI, you can get your SSDI and then Medicare 2 years later. SSI would be immediate with Medicaid. It gets a little bit confusing. And like I said, most of the time when there's SSI involved, If it's a concurrent case, it's that 5-month waiting periods when the SSI kicks in. So you might have Medicaid for 5 months, and then when the SSDI kicks in, it might eliminate your eligibility for Medicaid because of earnings, and then SSDI and Medicare kicks in 2 years later. They make it really confusing. It's not at all intuitive, but that's kind of the way it works. So the big picture to remember is there's a 5-month waiting period in SSDI. There's no waiting period in SSI. You can go back, get paid 1 year prior in SSDI, date of application SSI, Medicare SSI, Medicaid SSDI. And other than that, it's just going to be kind of case by case. But it is very, very confusing, Kevin, but that's kind of the big picture rules. Okay. Walter Knott put out a video last night that 2026 is going to be a major year that hundreds of thousands of people are going to be subject to CDRs and lose benefits. He said SSA does not need permission. They don't need HIPAA compliance. We'll get all the future medical records they want. AI will find words like improvement, other changes, and take people off of SSDI. He says Biden's O'Malley made it to where they could auto-grab medical docs from medical facilities. He's talking about the HITMER, HIT, Health Information Technology, and basically, on and on, and so forth. So basically what Walter must have talked about in his live stream or videos last night was that SSA now has the ability to get medical records very easily. And the way they do that is, and just so you understand what he's talking about, there is something called the Health Information Technology, or HIT, HIT, where Social Security has electronic relationships with a lot of big medical providers. Not every provider, but big hospital systems and big practices, yes. And so when they request medical records, instead of having to get it mailed to them, it's automatic. They can get it literally in a few minutes directly from the medical provider. And so what Walter is concerned about is they're going to use AI to go through those records and look for terms like improvement or reduction in medication, things like that. I'm not quite as pessimistic as that. I mean, I agree with Walter that the technology is getting to the point where you can use AI to parse medical records and find things. Let me tell you this: I use AI to prepare my hearings. Easy for me to say. And I'm using, fairly sophisticated AI tools, which Social Security is not really sophisticated at this point. It's pretty basic stuff because they've got all the privacy issues. And I use paid versions of Notebook LM or Chat GPT and so forth. I will tell you, it is still far from perfect. There's also a program I use. It's a HIPAA compliant program to go through the medical records, which is how I do that. And again, it does help, but it would not be something I would rely on, because I've noticed a lot of things will be missing or be misstatements and so forth. We are still, in my opinion, 1 to 2 years away, at least, from AI being this real concern about that they can rely on it to track medical improvement. Because again, what AI would do is it might look for certain words, but what happens if the doctor's notes are handwritten? AI is not going to be able to find that. What happens if they search for, or the program searches for something like improvement? Well, that doesn't necessarily mean medical improvement. Somebody's going to still have to look at it. So I think we're still a couple years away. But I would agree that, Frank Bisignano, the new commissioner, is very much a fan of technology and will use technology to try to make Social Security more efficient. I also would agree that there is a real emphasis on these CDRs. They do want to get people off disability. This current administration is not sympathetic to that. I'm just not quite ready to say it's a crisis situation. I think that the AI tools, while they're really good, are not perfect, and I use them every single day. And I use very sophisticated ones. I've developed my own prompts. I'm right now in my 8th version of my prompt. It does some really good stuff. I use, again, this program that will go through the medical records. It is by no means where you could rely on it to cut somebody off. And I think, again, a human being's going to have to look at it. Social Security has the problem of not enough human beings. So again, I would say a couple of years before we have to really worry about that, maybe even longer. But yeah, it is something looming on the horizon. And of course, the other part of it is that, if AI is looking at medical records and you ask it, has there been significant medical improvement? If there hasn't been, then AI will tell you. You still have the right to appeal that. And, I suspect what would happen would be, if AI starts kicking people off, there will be litigators who will, force Social Security to reveal the prompts they use. It's called discovery. They force them to reveal the prompts they use. And if the prompts are designed to, look for things that are really not representative of what's going on, I think there'll be, court cases that will prevent that. So, there's some guardrails in place. I think we're not quite at that point where it would be, time to panic. But, I agree that there's going to be some changes. What those changes will be, I don't know. Social Security, I would agree, in a couple of years may look very different than it looks now. Look, I think, I may have said this on the live stream before, when I look at a case, somebody emails or calls and gives me facts of a case. I've done this for 30 something years. The AI is right up here. I know just from listening to the facts of a case, there's a pretty good chance I'm going to win. And, if I listen to the facts and it's a weaker case, a 35-year-old with a bulging disc and insulin dependent diabetes, that's probably not a really good case. A person with a herniated disc, nerve root impingement, insulin dependent diabetes, and maybe they've got, pulmonary embolisms, they've got some blood clots, maybe they've got emphysema, that's probably a winning case. So, AI could do that. I mean, you could probably figure out, given the thousands, tens of thousands of fact patterns they see, and you could knock off, the 10% of judges that are very low approval and 10% that are very high, and you could create an analytical tool that would figure out who's deserving of benefits and probably be, 90% correct. Now, I don't think Social Security wants to do that, because what that means is that more people would be approved more quickly, and they want to keep the money, out of your hands and in their account. But, the data is there. There's enough data to I think, create a fairly robust analytical tool to figure out who's deserving of being approved. Will they use that? Will they use a version of that for continuing reviews? I don't know. I suspect it will. That will happen. But again, if you're truly disabled, you've got significant medical problems, a few words in a report is not going to make your cancer go away. It's not going to make your bad hip go away. Your need for hip replacement. It's not going to make your herniated discs go away. You're still going to have the underlying problems. And if Social Security starts relying on the technology, and there are enough decisions that go against that, people challenge it and they get in front of a judge, and the judge sees that the Social Security's AI tool is incorrect, they'll tell Social Security you can't use it anymore. So some built-in guardrails there. So I'm not quite as pessimistic as what I think MD 775 is saying. But we'll see. We'll see. But I think it's something to keep an eye on. But I'm not quite that pessimistic at this point. But yeah, as far as the HITMER, what that means is that if you give them a release, they can use that release many times, not always. They can use that release to get your medical records. Now, some medical providers want a current medical authorization. It can't be more than 6 months old or a year old. If that's the case, they're going to have to ask you for another authorization. Some facilities want their own authorization. So it's not quite as simple. You've got 50 states, and every state's got its own rules, different facilities. There's a lot of privacy issues there. Hospitals do not want to get sued for HIPAA violations. So, it's not quite so simple as saying Social Security can get anything they want whenever they want it tomorrow. Not quite. not quite. It's not quite that simple. There's going to be some hoops they got to jump through, and again, the courts are going to be looking at it to make sure that there's a certain level of fairness. So yeah, we'll just have to see. But I do think that it could be some changes. Definitely do that. Again, you're saying that Walter says you can do this without the 827s. I don't think so. I disagree with that. I think you're going to have 827 is a medical release. I think you're going to have the medical release of some type. You can't just ask for medical records, again, unless there's some sort of a law that I'm not aware of that lets them do it. But I would think that there's got to be some sort of medical authorization there. Okay. Hakasad, one of our regulars. How much does an ALJ rely on the DDE in their adjudication of an appeal? If you're following an ALJ, I think appeal, what information should I include, et cetera, et cetera. Okay, so what he's talking about is when you file for your hearing and you go to a hearing, there are reports and analyses by the the Social Security office, they call it the DDE or the DDS or there's any number of names for them, but this is the state agency that's made the decisions at initial and recon. And I look at those because, I try to find things I can use. And, the judge will say at the beginning of the hearing, I am not bound by any prior decisions. So point one is they're not bound by anything that the DDE does or DDS does. They will look at it sometimes. One of the things I look at it for is, did they make a determination of past work and what was the DOT code for past work? But again, a vocational expert might not use that DOT code. DOT stands for Dictionary of Occupational Titles. It's the job description from this book, which is outdated, last updated in the 1990s. You can see it at occupationalinfo.org, the DOT or Dictionary of Occupational Titles. I look at it to see what they came up with, and a lot of times it's the same thing that the vocational witness uses. And I also look to see, did the DDS give me something I can use? Did they find, for example, that my client's claimed impairments were severe? And that is step 2 of the sequential evaluation process. So in my briefs, I will make note the DDS found, the state agency found these 5 conditions as severe, and ask the judge to take notice of it. And many times they will. They don't have to, but many times they will. The other thing I would tell you is that the DDS, at least for now, and this is going to change as things, kind of progress over time, but many of these cases when the DDS got them, the look back was 15 years, not 5 years. Or some DDS, specialists don't realize that the past relevant work look back is 5 years, it's 15 years. So I have seen cases as last week, 2 weeks ago, where the DDS found that the claimant could do past relevant work, but it was a job that was from 7 years ago, 10 years ago, not relevant anymore. So in my brief, I'll point out, that the DDS found this is past relevant work, but it's been 5 years from the date of the hearing. It's not past relevant work. And therefore there's no past relevant work, which makes meeting a grid a little bit easier. So, there's a lot of mistakes in there. I've seen the DDS, draw conclusions about things that are ridiculous. A person with, severe, bilateral knee, knee problems that need knee replacements and, vascular necrosis in the hip, severe pain, and they're complaining of pain, and they're on, Norco, and they're on, all kind of Oxycontin and hydrocodone and all that stuff. Person could go back to skilled work. Well, no, they can't, because it's too painful and they can't focus and concentrate. So the DDS is a good place to start. It gives me some kind of a guideline as to what they're thinking, but judges are going to go way beyond that. They're not going to pay attention to it. They may look at it just to see what the DDS did. And every once in a while, believe it or not, if we take the DDS's conclusion about a person's, let's say the DDS says the person's limited to light work and they're 57 years old at onset, but they were found disabled because they could do past work, and the past work was something that was 7 years ago, so it's no longer past work. I'll say in my brief, the DDS found the person's limited to light work, and they denied it because they said past work. There is no past work. Based on the DDS's conclusions, this person meets a grid rule. And I've had judges say, yep, we're going to go with that. So, you can use the DDS's work against them if it's in your favor, or you can say ignore it because it's not, correct or not relevant. But judges don't really rely on it because, there's too many potential issues. The big one being that the time factor. When the DDS looked at a case, it might be 2 years ago, a lot has changed. There'll be new medical, the past relevant work issue could be a problem. So they're not going to rely on it. All right. And then the second question is, in filing I think you make ALJ appeal, what additional information should you include? A brief, other medical reports? I mean, I do a brief in almost every one of my, let's see here, clarification, time of filing an ALJ appeal, what additional docs? Okay. I think you said ALH, meaning ALJ. All right. So when I realize a couple of things. When you file your request for a hearing, number one is, as of the date you file that request, you or your attorney are responsible for getting the medical record updated. So the DDS, is not doing it anymore. Now, the one exception to that is that HITMER, which I talked about before, the HIT medical records, we call it HITMER because medical records, MER medical records. But the HIT system, the hearing office can get the records through the HIT system. So we will tell, if we're requesting a hearing, and let's say it's 3 weeks after we request it, the client has gone to a hospital, we'll notify the hearing office, get these records, and they'll get it for us, which is really helpful for me because I don't have to try to go through the whole process of getting medical records mailed to me and all that. So in that sense, it's really, really helpful. So I think you want to make sure you look at the exhibit file, make sure that the record is as up to date as it possibly can be, ideally within the last 2 or 3 months. If there's something recent, like there's a surgery or there's an MRI, you may want to get even more up to date, 2 weeks or a week, because you can get that now. I do a brief where I will spell out, I'll go through the 5-step sequential evaluation process. Is the person working? No. If there's earnings after onset, I got to talk about that, what those are. So I try to say there's no SGA or substantial gainful activity level work or activity after the onset date. Step 1. Step 2, is it severe? Again, the DDS say, yes, it's severe. There's medical evidence. Here's the exhibit number. So this is, yes, severe. There's something there that could be disabling. Step 3 is they meet a listing. I usually say we don't meet a listing because rare that you do it in a hearing. Step 4, could they return to past work? Maybe there is no past work because it's been more than 5 years, or past work required, mental and cognitive capacity way beyond what the person has. And then where most cases lie is step 5, could they do any other kind of work? And that's where the grid rules come in. That's where functional capacity comes in. So I just try to go through the analysis they're going to go through. You want to get those medical records in. I think that get them in sooner rather than later. No reason to wait for a hearing date. Just get them in, and get that brief in as soon as you can, if you're going to do that, and let Social Security look at it. I mean, I'm right now about 3 weeks ahead of my briefs. I got briefs done for cases at the end of the month. I'm thrilled about that because now there's a better chance that the judge might decide to approve my case without me going to a hearing at all. So I'm really focusing on that. My New Year's resolution to get my briefs done way, way early. And again, some of the AI tools I'm using help me with that a good bit. Okay. Hits for life. Just saw an ALJ for the 4th time. Unbelievable. The VE said there were jobs available, but when questioned by a lawyer, said none. You've got chronic bilateral radiculopathy, an L4 and L5, so bad. And then asthma, depression, anxiety, gastritis, fibro, sleep apnea, cognitive impairment, CE, physical and mental, unable to do sedentary work. You got a 32% judge. Terrible. That's not good. Back surgery, 7,000 pages, 45 years old, college degree. The things that jump out at me, obviously, are the 32% judge. That ain't good because that's a very low approval rate for a judge. The fact that you're 45, not great. It's going to be harder. But the fact you keep getting remanded, at some point, the judge or a judge has got to realize that the federal court, the appeals council, keeps remanding it. They're sending them a message. This case should be approved. Hopefully they pick up on that. But yeah, it's got to be really frustrating to go through this long delay and over and over and over. And you keep getting judges who don't want to, give you the benefit of the doubt. But like I said, my sense is, having read a lot of remands from federal court, that you can tell when the district judge is saying to the ALJ, I'm telling you, approve this case. Doesn't always resonate, but that's probably what's hopefully happening. All right, Tom. Yes, I did get that information. Tom is one of my clients. Yeah, we can. I mean, and basically what he sent me was he's got ulcerative colitis. Obviously is what he was telling us here, not revealing anything. And we had talked about where this may have come from, and it may have been come from exposure to chemicals in his past. And so there's a lawsuit that's going through that, and he sent that to me. And I think the point he said, as far as whether it's relevant or not, where it came from is marginally relevant because it might explain it. But the point is, if you've got ulcerative colitis and you've taken medications and you've got medical reports saying it's not under control, that's really the important thing. Where it came from may be less important. We may mention in our hearing, I may say, any idea where this came from? And he can say, well, when I was in the service, I was exposed to chemicals. And in fact, I'm involved in a lawsuit with other people exposed to the same chemicals that have the same problem. That's all we need to really do about it. So yeah, I think that I did get that information. Let me also say that Tom, you did something really, really smart. And that was when we were talking about doing our pre-hearing, you wrote out a number of questions and answers. And I don't want you to read it at the hearing, but you wrote out your thoughts about, why you couldn't work, how frequently you have these episodes, all the things that we talked about, the questions you're going to be asked. And I think that's a really smart move. So if you are getting ready for a hearing and you're going through your pre-hearing and your lawyer asks you, these are questions you're likely to get, sketch out your answer. It could be copy points, but that way you don't forget, and have it in front of you. It's a telephone hearing. No one's going to see. You have it in front of you. For example, if you have, we'll use ulcerative colitis. If you have to use the restroom 7 to 10 times in a day, just put a little bullet point, 7 to 10 times in restroom, 15 to 20 minutes each time, painful cramping. That way, you get those points across when you talk to the judge. And Tom did it. He wrote out a bunch of questions, and I'd given him a list of questions that I see a lot of, and he answered some of those and wrote it out. Really smart. I think that's a good thing to do, because you're going to be a little nervous and you might forget something. And again, I'm going to ask you, because I've got it all in my notes too, but there are judges who will say, tell me in your own words why you think you're disabled. So you want to be prepared for that. Okay, Jennifer, how are you doing? Jennifer, we got an approval on our case, and I saw the approval come through. I subscribe to a service called Chronicle that logs into my electronic express account, and I can see when the cases are approved. So I mentioned I had only 2 so far this month. I got 2 more today, and Jennifer was one of them. So it literally came down about an hour and a half ago, and as soon as I saw it, I immediately downloaded it, sent it to her, and said, we won. And you've been waiting a long time. I know. I'm glad we got good news, and I'm glad to share that with you. So I like to tell my clients, as soon as I see it, if it's not good news, we got denied, I'll tell them that too. But I get access to it. Your lawyer will get access to it pretty quickly. But yeah, 3 years, a long time. I am so glad that you were deserving. You should have won. And we had a reasonable judge, and all worked out. So I'm glad. Thank you for tuning in. Okay. All right. It's time for my annual functional review. All my symptoms are the same. Some new injuries. My symptoms are cervical dystonia, chronic headaches, CRPS, sacroiliitis. They still try to deny you. When you say annual review, normally most cases are not reviewed annually. I mean, if your case is coded where improvement is very likely, you might get a look annually, but usually it's 3 years or so. I mean, you should assume and you should prepare for an annual review. Continue to go to the doctor, keep your symptom diary, keep your medication list and so forth. But I think if the symptoms are the same, they remain at a disabling level, yeah, if there's nothing for Social Security to rely upon to say there's been improvement, AI or not, and the symptoms are pretty much the same or worse, then you should be fine. I think that people get really freaked out about that. And the ones that, the cases I see where they've been, moved to terminate would be person has not gone to the doctor. That's a big one. Where the medical records suggest significant improvement. That's another one. Or the person was really young when they got approved. They were 25. Now they're 35. They're still young. And Social Security's gotten around to looking at it, and they're looking for a reason to cut you off. So that would be one of those situations. But, generally speaking, I haven't seen percentages, and that would be interesting to know. But I don't get the sense, up until now at least, that a huge percentage of people are being cut off, especially if you haven't worked and then you're going to the doctor, the medical record's pretty much the same. 2 years, try 6. I'm not sure what that means. Maybe 2 years to get from it shouldn't take 6 years to get to a hearing. So if that's what you're talking about with that, but so again, maybe you can explain what you mean by the 2 years and 6 years. Is there an EBT rule for back pay? Just got half of your back pay after a year in Indianapolis. I don't know what EBT rule is, but why do they only give you half of your money? That doesn't make any sense. If you got a letter saying you're entitled to $33,000, why would they pay you half of that? That doesn't make any sense at all. That might be something that you should talk to your lawyer about, because that just does not make any sense to me at all. Now, I did have a situation where, and this just goes, I may have talked about this before, fee petitions, where I had a case and my client had a lawyer who died and didn't have anybody in the office to follow up with. And so I took the case on thinking, I'm going to file a fee agreement, my standard 25%, and there shouldn't be a problem. The lawyer's dead. Nope. Win the case. My fee agreement gets denied because there's another lawyer. I write the judge, the other lawyer's dead. He writes back, well, we need a withdrawal. You can't get a withdrawal. I can't approve your fee agreement. File a fee petition. This is over 5 years ago. They sent me half the money, and they sent the other half to, I have another attorney in the office who does this work a little bit with me, does some other work with me as well, being of counsel. They sent her the other half. I have no idea why. So fortunately, it's in the office. She'll put it in her trust account and then disperse it to me. But she's going to have to send me a 1099, so she didn't have to pay taxes on money she didn't get. But finally, after 6 years, I think I finally got paid on this case, where I tried to do a good deed. The client, lawyer had died. That's why I don't take cases with a fee agreement, fee petitions. Not worth it. All right, Fan Cave Collectibles, fully favorable for my hearing on December 17th. Almost 6-year fight, 3 hearings, 1 federal district court case sent back. AC remanded it, 3rd hearing, gets a favorable. And this is the system, I mean, my guess would be the first remand went back to the same judge. The second time went to a different judge. And that's a good thing. But yeah, it shouldn't take 6 years, but this is what happens. This is what happens. Social Security is a huge bureaucracy. And if you happen to get the wrong judge, I hate to put it this way, because it sounds like a lottery. You get the wrong judge, you got a big problem. You get the right judge, your case is, a much better chance. And it shouldn't be, but there's some judges who just don't believe in. There's one judge, I've never had him, like less than 10% approval rate. Why would Social Security put up with that? And I've asked some of my colleagues who do a lot of appeals work, Carl Osterhout or Adriana De La Torre, can't you, raise that issue on appeal that this judge approval rate is so far beyond the standard deviation that it's inherently unfair? And they tell me no. If I have a judge that has that really low approval rate, I'm going to raise it and see what happens. I just can't. It makes no sense to me. That's just inherently unfair. But whatever. Okay, EBT letter, $5,000 in a bank account. EBT, unless you're talking about food stamps or something unrelated to Social Security, not really sure what that's all about. if you're asking about something having to do with food stamps or some state benefit and back pay, I can't answer that because I don't know the state's rules. Okay. Hello. And you know what? You don't call me. No, you don't have to call me Mr. Ginsberg. Jonathan's fine. I'm pretty informal. Hearing 2 weeks. Please advise me to ask my attorney what you should ask your attorney. Okay. I think that what you should ask your attorney to do would be to, number one, go through the actual chronology of the hearing, what actually happens when you start. Just I call it where to stand. What are you going to be asked? You're going to be asked, for example, to confirm you're not recording the hearing. You're going to be asked to confirm you're okay with a telephone hearing or video hearing. There are certain questions you're asked, and then the judge will ask, your attorney certain questions. Will he waive a formal reading of the issues and things like that? And I just go through the actual process. The who's asking what the vocational witnesses going to be talking about and what that's all about. And then I go through a list of questions, and what I typically do is I print out a list of questions that I've just built out over the years for my clients, and I send it to my client ahead of time. And I include in there some suggested, and I should say this is correct, not suggested answers, some typical answers. Always tell the truth, but realize that, if you've got 2 herniated discs and the judge says, how much can you lift? You may think of yourself as, okay, I'm still 18 years old, and I can do anything. And you may say 50 pounds or 30 pounds, not thinking that, okay, I'm now not the same person, and even 5 pounds or 10 pounds is a problem. And I can't tell you how many times when I'm talking to my clients in pre-hearing, and I'll say, how long can you stand? Or how much can you lift? How long can you stand? I can stand for 3 hours. Really? You've got plantar fasciitis, you've got 3 herniated discs, and you've got hip dysplasia, and you can stand for 3 hours. Really? Could you? Think about that. 3 hours is, this is what, well, I guess you're right. This is probably closer to 15 or 20 minutes. Well, a big difference there. How much can you lift? I can lift 50 pounds. Really? You've got, you've got diabetic neuropathy in your hands, you've got a herniated disc, and you have carpal tunnel. You can lift 50 pounds. Well, I guess, could you hold a gallon of milk? No, couldn't do that. Well, that's 8 pounds. So, there are a lot of times people just overestimate, or they think about when they were stronger or younger. So it's important to kind of have a sense of what judges normally hear. Now, I've had clients that tell me I could lift 30 pounds. Like, okay, you can lift 30 pounds, then that's what you testify to. But people tend to overestimate what they can do as opposed to the other way around. But yeah, I would ask your lawyer to give you a list of the questions that he or she thinks are likely to be, asked in the hearing, and, practice the answers. And like we talked about with Tom, my client Tom, he wrote them out. So I would tell you, get the questions that you're likely to get. I think I did a video, certain questions you're going to get in every single case. Look for that video on my YouTube channel and just write out your answer to it. You're going to be asked about your past work, what you did, how much you had to lift, how physical it was, how mentally demanding it was. So be prepared for that. You're going to be asked about your medications. You need to know what they are, what the side effects are, what they treat, and are they effective? You need to know what your main medical issues are. Is it back disc issues? Is it depression? Is it fibromyalgia? Is it, some sort of an organ problem, cardiac problem, liver, lungs? You need to know those things. And really, I would even tell you, put them in order of severity and be able to talk about the specific functional issues that arise from those medical problems. So you're not just saying, oh, I have a congestive heart failure. What does that mean? Does it mean you're limited in terms of how far you can walk and you get out of breath and you need to lie down during the day? These are the things you need to talk to your lawyer about, making sure that you get those questions so that you know how to answer them and practice with your lawyer and see what the lawyer says. He or she may tell you, you need to offer more detail, or you're, a classic problem that I see a lot is the judge would say, or the question would be, how far can you walk? Not real far. How much can you lift? Not too much. What do you do around all day? I piddle around, don't really do much, go out to the workshop sometimes, can't get much done. What if you've given no information? And so you got to be real specific, 10 or 15 minutes, 30, 30 yards, 15 steps, whatever it may be. I lie down for 30 minutes, 3 times a day in a recliner because the pain in my back gets so severe. I need to take all the pressure off. You got to be real specific. And that's what your lawyer can help you do. Okay. Christy, what is the difference between the letter stating final decision and the award letter? Well, if you're talking about either an administrative decision or a hearing decision, that will just say you are disabled by our rules. And the award letter will go through the numbers, the money, how much you're going to get, what months they're going to pay you for. Are there any offsets, things like that? That's what the difference would be. 47 GMC, I hope you're doing good. I'm, like I said, trying to stay a little bit warm, but yeah, doing okay. Just, it's, I'm not a big fan of the cold weather, but I do have heated socks. I bought some heated socks online, and I plugged those suckers in, and it's got a little battery, like a just like a little power. I don't know what you would call it. Looks like the size of maybe a Tic Tac box, and it's just a little power bank, and you plug them into the socks and heats your feet. That's helpful. I got a heated jacket. Same thing. It goes on my jacket, and Uro, I think is what it's called. You can get them now for like $20-30. And it basically, the jacket's fairly thin, but it's got heating elements in it, so you can turn it up. And when you go out in the cold, you just have the heated jacket going on. I got a heated vest when I play tennis. I got a hat, a big thick hat with ear, protection. So yeah, you get yourself properly accoutered, and you go out there. And if it's 30 to 40, not too bad. Gets below 30, hard. That's kind of hard to really deal with that because the hits your face and it's just not real comfortable. But yeah, doing okay. Just having a great time with my grandbaby, who's about 2.5, and every day something new, and playing a lot of tennis and writing a lot of briefs and trying a lot of cases and winning a lot of cases and doing my live stream. And what else is there? So all's good. Okay. Millionaire movement. I'm in Florida now, 1 year at the recon stage. How much longer? 2 back surgeries, eye surgeries, haven't worked since July of 23, living with chronic sciatica nerve pain. Florida is one of the worst, I got to tell you. I mean, I have a lot of cases out of Florida, and the recon, 15 months is not uncommon, not too much longer than that. What I would do, quite frankly, is I'd look up your senators. I think it's Senator Scott, and let me see the Florida senators. It is Rick Scott and Ashley Moody. Go to their website, one or the other, not both, but go to one or the other, and you'll see it says help with a federal agency. And you fill out the form and basically say, I applied for Social Security disability, whatever date. It took X number of months before I got a denial. I filed my reconsideration in January of 2025. It has been a year. I'm not hearing anything. This is causing a lot of hardship, and it's taking way too long. Can you find out what's going on in my case? And believe it or not, that will get your case processed. I'm not going to say approved. You'll get a decision, good, bad, or indifferent. But yeah, when you get to that point, you're a customer for the politicians. You're a voter. And if they help you, by getting your case, a decision in your case, you're going to tell your friends and relatives, hey, Rick Scott helped me with this. I may not agree with Rick Scott politically. He's a Republican, I'm a Democrat, or whatever it may be, or he's a Democrat, I'm a Republican. Rick Scott has to be a Republican. I may not agree with him, but you know what? He helped me. So I'm going to vote for him. Or I would, I think he's somebody you should consider. That's what they want. And, how hard is it for them? They just have one of their staff people write a letter. Social Security, they get a letter from a member of a senator. They jump up and they deal with it right away. It's a win-win for everybody. So yeah, I would do that. Okay. All right. So this is the person who asked about being reviewed. She has a spinal cord stimulator, which is not really helping much. And what that is, if you don't know, they implant this thing. It's like a stimulator. it's got electrical connections, and they attach it to nerves, I guess to the nerves in your back, and it sends out pulses. And what it does is it overstimulates the nerve so that the nerve does not conduct pain impulses. And so people who have chronic pain that are not otherwise surgical candidates, you flood the nerves where there's pain with signal, and so it doesn't process the signal and it relieves the pain. It's not a perfect remedy. It can help a little bit. It's usually done, a spinal cord stimulator done when there is, no surgical option anymore, and you don't want to go with medications, and the medications aren't real helpful. It's just another way to address pain. I think it's, kind of an imperfect way of doing it. I've never met anybody who basically had spinal cord stimulator and it restored their function. It basically might make the pain a little bit less, but it's not going to solve the problem. So again, if you're at that level, I don't think you're going to get reversed. They're not going to cut you off, I don't think. Okay, so this is the question about EBT. I'm thinking, let's just see, make sure I'm EBT. I'm guessing that's food stamps, electronic benefit transfer. So I don't know, what the rules are as far as qualifying for food stamps, whether you having too much money in your account disqualifies you. That's kind of a state law question. But in Indiana, I wouldn't be able to answer that, unfortunately. Okay. From my experience, is the purpose of filing an ALJ appeal to obtain a de novo adjudication? Okay, I think you already answered that. It's a de novo, which means new decision, new adjudication. They're not bound by anything. Lady essay, I'm 65 years old. Applied for SSDI in July 2023. Recon began 24. Been sitting without a caseworker assigned in Georgia. Lawyer is Lindsay Osterhout. 3 congressional inquiries done. Lindsay is really good. She's a good friend of mine. Knows what she's doing. And, unfortunately, if Social Security doesn't have the personnel, I can stand on my head and, juggle, a bowling ball. Not going to make them assign an adjudicator. This would be one where reach out to Senator Ossoff or Warnock and say, look, it's been a year. Recon has been sitting there. There's no caseworker assigned. This is causing me hardship. Will you help? They will write a letter to the head of the DDS. Lo and behold, a caseworker will be assigned. Will it mean you're going to get a decision in 3 months? No, but at least things will get moving. But you're in great hands with Lindsay. She's very, very smart. She and I talk, frequently about cases. If I have questions, I'll call her. She's called me a couple of times about things, and we're good friends. And I refer my appeals work to Carl, her partner, we deal with them a good bit. So they're good folks and very, very capable and competent lawyers. You're in good hands. Mama Deb, will Social Security request medical records from my doctors, or have to get them physically? Want to apply for SSDI? That's a very good question. The answer is they will get them. What you have to do is provide them with the names, ideally the addresses and phone numbers and fax numbers of all your medical providers, so they can get them easily. They like to get them. If you look back on my live streams, I had a woman who used to work at DDS. She was there when she did the live stream. She's now moved on to an insurance company. And she went by the name of Linda, I think, on the live stream. That's not her name, but she went by that. Protect her privacy. And she said, as an adjudicator, I want to get these records. I want to make sure that they're accurate. I want to make sure they haven't been, messed around with. People have removed stuff, scrubbed in some way. But just give me where I need to get them from. So that's what I would tell you to do, is make a list of all your providers, based on your onset date, maybe go back a year or two. And anybody you've seen, within a couple of years of your onset, make a list. That will be part of the application. In fact, if you go to ssa.gov/apply for disability, there's a little printout there of what you need to apply. And that's one of the things, is a list of all the medical providers that you've had in the last few years, and that's what they're going to need. And they'll get the records. Let them do the heavy lifting on that. All that being said, there are times, and on a frequent basis, where we have to supplement what they got. Some medical providers do not cooperate. They get the letter from Social Security and they don't respond to it. The reason for that is not that they're trying to hurt you or anything like that, but doctors' offices don't get paid to provide medical records. And it's a full-time job for staff people there to respond to these requests. Many of them use services like SIOX is one of them. There's a couple of them out there. And these services, have access to the computer records, and they will respond to medical record requests. A lot of these requests come from lawyers, not surprisingly. In the personal injury, workers' comp, that type of thing, that area, they can charge money for those records. They may be able to charge 10 cents a page or a retrieval fee of $35 plus 5 cents a page. Every state's got different rules on that. And some states say if you're requesting these records for purposes of making a disability application, there is no charge. And of course, the HIT system is another way to get those records. My point is that sometimes you send a record request, Social Security sends a record request to a facility, let's say a cardiac practice, and they use SIOX. And SIOX gets a request for medical records, and they say, well, our fee is a $35 retrieval fee plus X number of dollars. The cost of these records is $85.74. And send it back to Social Security. Social Security says, we'll pay you $10. That's it. And they don't respond to it. They don't send the records. That can happen. So sometimes in those situations, we may have to go in as the lawyer and go to the patient portal and get the records. So, it would be nice if you as a claimant could look in real time to see what Social Security has. I can do that. I have access through Chronicle or through the ERE, Electronic Records Express. I can see what records Social Security has obtained. I can see what they're having problems with. And so I can see pretty early on where there's a holdup, in which case I might go to the portal and get the records, or I might call the client and say, you need to tell your doctor to cooperate. Unfortunately, there's no way for you to do that. I wish there was, but there isn't. So, and to tell you to call the adjudicator and say, what are you not getting? You're not going to get through. So that's a problem. But, I don't think it's a mistake for you to have your own copies of these records. Keep them available and let the adjudicator know you've got them, so that if they need your help in getting those records uploaded, you can do so. But you don't generally have to do it by yourself. Okay. Kiana Minnie, I hope everybody's doing well. I have a question. I submitted my short form CDR, which is like 5 questions. I just received a letter saying they do not need to review my case at this time. Will they continue sending CDR? So basically, what Kiana said was she got a short form. They sent it in. Social Security says, we're not going to take this any further. You remain on benefits. You may get another 3 years, 5 years. It just kind of depends. Part of it is how your file is coded. Is medical improvement, likely. Some of it's kind of random. So you probably will be reviewed in the future, but it probably will be 3 or 4 years from now. Oh, okay. T-Bond, it's been quite a while since I've been here. Yes, I do remember you from last year. Hope everybody had nice holidays. Thank you. My question is regarding back pay. If they claim they overpaid SSI, which did not receive, how long will it take me to pay the portion that they're holding? So if they overpaid me for SSI, the only thing I'm thinking is at the beginning, maybe you applied for SSI and they paid you some SSI. It turns out you weren't eligible for it. What I would do is there is a form. Let me see if I can get you the form number. To repay. Where you can ask for an installment payment or a waiver. I think it's form SSA 632. Just look up Social Security Disability Overpay requests for waiver or request for payment plan, and in Google or something, and it'll come up. I think it's form 632. And at that point, you just fill that in. You can ask for a waiver. Let's see, I'm just looking at it real quick here. So anyway, you can that's not, maybe that's not the right form, but that's where you were asking for a waiver. I think you can request. Let's see, request for payment plan, SSD overpay. Request for change in overpayment rate. That's SSA 634. So look up SSA 634 if you want to try to get to a payment plan, or what I say, 632 if you want to get a waiver. You can do those and just see what happens. So that would be the starting point there, as opposed to, having to try to pay it all back in one big lump sum. Florida Raider fan. My wife is currently SSDI. I'm retiring. Can she come in my retirement? If she comes to my Social Security, half my Social Security increase hers by 600. What's the process? You're asking about claiming and retirement Social Security, which I don't really do. I would tell you, that's something there are people out there who do Social Security consulting. Maybe your CPA can do it, but I know there are people out there who do consulting with that. That would be who I would ask about that. I don't deal with claiming issues in retirement Social Security. It's just beyond the scope of what I do. You could ask like ChatGPT or something, but again, you got to be careful because it may or may not be correct. But I would try to find somebody who does retirement planning. In my opinion, it's better to apply in person or by phone. I'm already getting early retirement, so I can't apply online. Only take an early, think I'd still be working. I think phone is going to be better than in person, because trying to get an appointment is going to be really, really hard. Isn't Social Security supposed to make the case, Charity Spencer, that the person can make SGI, I think you meant SGA, substantial gainful activity, which is $1,690 a month gross in 2025, and continue to work 8 hours a day, 5 days a week? So I think what you're asking is who has the burden of proof. And remember, I talked about the 5-step sequential evaluation process. Up to step 4, you've got to prove it. You've got to prove you're not working. You've got to prove you've got a severe impairment. You have to prove that you meet a listing. You've got to prove that you can't do past work. Once you've done all those things, step 5 is can you do any of the work at all? It's their burden to prove that you can work. So yeah, they're going to basically argue that your medical evidence and that the language they use in unfavorable decisions is the same one they're going to use in an administrative denial, that your allegations of impairment are not entirely consistent with the medical record. The medical record suggests that you have the capacity to do some sort of a simple entry-level warm body job, 8 hours a day, 5 days a week. So that's typically what they're going to argue. But at step 5, they've got to prove it, yes. All right, so MD77SA says that Walter said that they're getting a new DOT or job book. Again, there has been a lot of talk about this. They spent a lot of money. The one thing they have done is they recognize there are other sources other than the DOT. And in fact, there is a ruling that judges now ask every vocational witness to talk about their methodology. That's to satisfy a court case that said the VE can't just say, I follow the Dictionary of Occupational Titles. So they have to go beyond that. There has been a lot of talk about them finding a replacement. To my knowledge, there's nothing in the hopper. They're still studying it. There's something called the ONET, which is out there. There are these codes called the SOC codes, specific characteristics of occupations. The problem is they don't line up all with the DOT. And so you may have, for one DOT code, let's say, I don't know, a nurse's assistant, there may be 6 SOC codes. So there may be numbers about how many jobs exist within a particular SOC code, but if there's 6 SOC codes, and let's say there's 100,000 jobs, how does that translate to how many jobs for that DOT category? Well, you can't just say, take the number and divide by 6 and say, well, we're just going to take one of these because one of those codes may entail 95% of the jobs. So it's a real problem coming up with numbers. The reality is nobody knows how many jobs of a particular occupation actually exist. Second thing is there's no really accurate resource that describes every job that exists. Every job, there's going to be something unique about just about every single job. You may have a job as let's say a line cook, but that may also entail doing some cleaning up. Well, the cleaning up part may make that job move it from light to medium. So it's really hard for vocational witnesses. And that's why they have them, is because the vocational witness can say, look, Judge, I have placed people as nurses' assistants. I have placed people as, cosmetology assistants, whatever the thing may be, or warehouse truck drivers. So I know what the requirements are, and the DOT's description or the ONET's description or the whatever other description they got talks about this, but I know it's actually requires these other things. I had a hearing yesterday where the VE talked about the description of the job was described by the DOT, again, which is 35 years old, as a light job. And this gentleman was a construction inspector. He would work for companies, and he would go around to job sites to make sure that the buildings were meeting code. He had certifications in electrical and construction and masonry and all these different types of things. And so his job was to go around to make sure that the subcontractors were doing their job and that it would meet code, so that when they had the inspection, they would pass. Because for a construction company, if they have a problem with the electrical system and it's been, everything's been, in conduit, it's in the middle of a wall, that they have to take out that wall to redo it. That costs them money. So, a lot of big builders or a lot of, contractors will have people on staff that go through and double check to make sure everything's being done properly. My point is that this particular situation, that job, as a construction, monitor, or where, I forget what the name of the job was, but it was described as being skilled and light. Skilled and light. Light meaning no more than 20 pounds occasionally lifting. Well, my client said it was 50 pounds. I'm holding jackhammers, I'm doing this, that, and the other. And the vocational witness agreed. She's like, yeah, because I've put people in these jobs and it's a 50-pound weight restriction. The DOT is not correct. So judges can take notice of that, and that would become evidence because the vocational witness is an expert witness. So, the resources they are using now are outdated, not especially accurate, and don't really reflect the reality of what's going on in the economy in 2026. The problem is we don't have anything better at this point. We got the DOT and related publications. We have a computer program called Job Browser Pro. You've got a bunch of other resources that don't really line up in terms of the phrasing they use or the categories they use, and gives a really incomplete picture of the job market out there. But Social Security has to have something. So they have kind of decided that we're going to take this sort of cobbled together, set of resources, And we will allow vocational witnesses to use these to talk about jobs. Can you rebut that? Yeah, theoretically you could, but then you run into the problem of, you start to challenge the VE in terms of, the way he or she analyzed the data or the data they use, and judges don't like that because it makes the hearings run really long, and they just like to keep the vocational witnesses, everything kind of clean. Now I was reading on Oscar the listserv today where somebody was talking about that the vocational witness made some comment like, I had to guesstimate the numbers, and the attorney smartly picked up on that, some of their term, but something like that. Well, what do you mean guesstimate the numbers? Well, I didn't have the exact numbers. I think like the example I gave, there are 6 categories of jobs in this, particular occupation. And so it added up to 100,000, jobs. And so I just divided it out and kind of took, 2.3 and multiplied times the average. And it made no sense is the point. And the attorney said to the judge, this doesn't make any sense. And the judge started laughing and says, I guess I'm going to pay this case. So my point here is that, you can go after vocational witnesses who offer, ridiculous ways to analyze things, but usually judges are going to give them a lot of leeway because they have to do something. In other words, if you could challenge a vocational testimony and basically get a vocational witness to admit that there is no good resource about how many jobs exist in the economy, part of Social Security's burden at step 5 is to prove that jobs exist in significant numbers in the economy. Well, if there's no information that is out there, how can they prove that it exists? So by default, every case should get approved. Well, they're not going to do that. So they rely on these sort of outdated and useless kind of numbers. And sometimes on appeal, you can make that argument, but sometimes not. It's just, again, I think Social Security's just made the decision, and the courts have made the decision. We realize it's imperfect, but this is the best we got. We're going to let them use it, which is a little crappy if you ask me, but that's what they do. Okay, if someone needs my help, how do they contact? I've got this crawl at the bottom, contact Jonathan 3 bit.ly, which is a link shortener /contact Jonathan 3, or go to ssdanswers.com. I've got a case evaluation form there, survival kit form, sign up there, but that's how the best way to reach me. Just go to ssdanswers.com. In fact, I'm going to change the banner now, where if you want to leave me a review, if you're getting use out of this, then please leave me a review. What we got here? Okay, Michael Armenta. Does SSDI make any distinction between central sleep apnea, where you stop breathing and your oxygen plummets, and obstructive sleep apnea? Yes, but again, the only real issue is how these affect you. And sleep apnea, the overall universe of sleep apnea is going to make, generally speaking, your sleep will be non-restorative, which translates to focus and concentration problems, which translates to you're not going to be able to do anything but unskilled work. That's the way how I look at it. So when I see severe sleep apnea, non-restorative sleep, then what I'm going to is this person does not have the ability to do skilled work or semi-skilled work. They're going to be unskilled because of focus, attention, concentration arising from the non-restorative sleep. Now, the central sleep apnea, when you stop breathing, that might cause other problems, because obviously loss of oxygen to the brain could cause more significant cognitive issues. So I think that, if you want to argue that it's more than just arguably eliminating skilled work, and there's something beyond that, you're going to need medical evidence to that effect. Your doctor, sleep doctor or general practitioner or neurologist, needs to say that having central sleep apnea could cause permanent brain damage. It can cause, a much higher level of difficulty with focus, attention, and concentration. It can cause mood swings, whatever it may be. And that's the reason why I would have trouble working. So it's a more serious condition in addition to the non-restorative sleep, but you have to have medical evidence to prove that. MD says, my approval at initial did not specify a time frame. Yeah, it's pretty normal. I don't normally see it either. As I understand it, and I've not been able to verify this, but that every file has got a code on it. Not a secret code, but there are certain code letters that you may see on letters that are sent to you. Certain codes that basically say this is a 3-year review, a 5-year review, or a 7-year review. And I have not actually seen the codes and been able to interpret it. I have a friend of mine who claims that he's been able to do that. I've not been able to get him to show me how it works. So I'm just going to go with there probably are codes someplace. Where they are, how you get a hold of them, I don't know. Whether you could ask the adjudicator for that information, I don't know. Whether you could contact your congressperson and say, I need to know what kind of review schedule I'm on. Can you find out? Maybe they can find out for you. So that's what I would tell you. All right. So Mark Benson says, got a hearing on February 19th. Main condition is sleep apnea, both obstructive and central. The last sleep study says the apnea is not controlled by the BiPAP. And AHI, which is a measurement of I guess, in the sleep apnea world, not exactly sure what it is 99, which I'm guessing is not a good thing. So, like I said, I would, you got to take to the next step and find out what that means in terms of your functioning. It's not controlled. We know that. We can assume some non-restorative sleep. Beyond that, what does it mean? That's what you got to get an answer to. That's where your doctor can be a big help to you. Or look on the Mayo Clinic website, look on ChatGPT, look on Google. What does it mean? Let's just plug this in right now. Okay, what are the functional issues that arise from central sleep apnea? Okay. So this is just a question I'm asking Google. Severe fragmentation of sleep architecture, which means, very poor sleep, no REM sleep. Cardiovascular stress, which you might not have with general sleep apnea, obstructive sleep apnea. Neurocognitive and daily impairment, hypersomnia, brain fog, headaches, which you may not get from normal sleep apnea. Low exercise tolerance. So these are things that, might eliminate categories of jobs. Again, the headaches might make it hard to deal with bright light, or might, again, cause more absences. Low exercise tolerance might limit you physically, even to the point of a grid rule situation. Daytime sleepiness, you're not going to be able to work around hazardous equipment or moving machinery or unprotected heights. That's what I'm talking about. That's what you got to take that. You take the diagnosis and the medical problems and you translate that into specific functional limitations, ideally with a blessing from your doctor letter or statement or something to that effect. That would be very, very helpful, I think. Okay. Charity says, I have a lot of help each week. I've been told it seems on mental health not being considered a full neuropsych, and it said severe mental health. Recently got ASD. Again, mental health is hard because it is invisible. You can't take an MRI of depression. So I think that having third-party statements could be helpful. The neuropsych evaluation can be very, very helpful. But sometimes you got to go beyond medical records, is what I'm saying. Maybe you get your attendance sheet from your prior employment showing how many absences you had. Maybe you get statements from former coworkers that talked about, emotional instability at a job, things like that. Hey, Stephen, Cassandra, how are you doing? They sent me an email, and I basically, they wanted to know, is a nurse practitioner considered an acceptable medical source? And the answer is yes. So they did email me and I responded back to them. I'm glad to see you here. Ginger Mittens Pie. I'm guessing you are a cat family. So, because you don't see too many dogs named Mittens. I'll just say that. Just a guess. Okay. The judge ruled on the record, fully favorable last week. My case was dire need, and allowed me to be rid of it by judge. In my experience, the dire need sort of stops at the hearing. It could be 3 to 4 weeks before you get the written decision, another 2 weeks before you see the money. So I would tell you, possibly up to 6 weeks, but you could get lucky. I don't know. Hits for Life says a question. Did I see it? I thought I did talk about that. You were the person who had the ALJ for the 4th time. Case was remanded 3 times, 45-year-old college degree. I kind of gave you my thoughts on that, big picture is that when something's remanded 4 times, usually the appeals counsel or the district court is giving the judge, ALJ, a message like, we keep remanding, want you to approve it. But if you have a low-paid judge, the judge may not care. You got to just keep fighting it. There's really no other way. I can't give anything else to tell you other than doing what you're doing. But if you get more functional capacity evaluation statements from the doctor, that could be helpful. But otherwise, it's just a real struggle, and it's unfortunate that you have to go through this. Can I explain what happens at a review for mental health? I assume you're talking about a continuing disability review. Do you speak to SSDI to review paperwork? Generally, they just review paperwork. They may send you some forms to fill out. And the real question they're going to ask, and I will tell you that mental health cases are the ones that they are reviewing more of those, because there's a perception in Congress that at some point in the past, Social Security was just handing out money willy-nilly to people with depression. And then a lot of people in Congress say it's a bunch of bunk. But people in Congress don't live the life that most people live. So, although John Fetterman certainly would know, he's the senator from Pennsylvania who actually, I think, had a psych hospitalization, still got elected. Interesting character, but, a lot of them don't really care, I'm guessing. They're going to mostly review paperwork. I mean, unless you ask for a hearing, they're not going to call you. I mean, to talk to you about your case. I think they're going to, you talk to a judge at some point, but otherwise it's done by paperwork. For Maka Pickett, I think was just asking about, continuing review, and what she's saying is really no changes in her medical situation. Should she be concerned? And my thought is no. I'm trying to find a lawyer to place your non-legal fee representative. Most places, it seems they don't take SSI, only SSDI. Yeah, that's a problem, because the issue with SSI is there is not a lot of money in it, quite frankly. Many SSI cases are subject to offset because of household assets or household income, things like that. And it's just harder to find lawyers to do them. I've got one right now, 1 or 2 in my office, but I don't really take them either, just because, you do the same work and you get paid, $300 or $400. It's just not worth it. Just going to have to keep looking. I mean, there are going to be lawyers maybe who are a little newer at this that might take one. Again, legal aid can do certain stuff for you. Maybe go to NOSCR, NOSSCR.org. There's a lawyer referral service there. Call your local state bar. Many of them have referral services. But yeah, it's a problem. It's a problem because, like I said, when I take a case, it could be a 3-year journey, a lot of work, a lot of paralegal time, getting medical records. And, if all that work and I generate $300 or $400, I'm losing money. So I can't take those cases for that reason. That it's unfortunate. That's just the way it is. Just got approved at 42. Had to 3-year move your onset date back. Yeah, sometimes they'll make you change the onset date to give you your approval. You got to make a decision about that. Is it worth it? How much money is at stake? All right. And Jody Maxwell says, I've been waiting for a court date, which is about 7 months. That's pretty typical. It'll be about 3 years from the start to finish. Unfortunately, that's not so abnormal anymore. I used to tell people 18 to 24 months, but Texas, Florida, certain states, 3 years is becoming pretty common. And again, this is where when you start getting beyond 5 or 6 months at a stage, that's where you contact your congressperson, I think. Kanan Bechtold says hello. Hello, Kenan or Kanan. Okay. 4 O'Clock Lover says, are there attorneys who would handle cases for Americans living abroad trying to apply for disability? I used to be able to answer this that, I would do it. A lot of people do it. Now there's this crazy new rule that says that they will not hold a hearing unless you are on U.S. soil. And I don't think being in the embassy is good enough. So like I had a hearing, I had a case last year, all ready for it, client's ready, get a call from the judge. She's like, I need to talk to you. I'm like, okay. I hate when they do this. Like I feel like I'm going to the principal's office, brings back bad memories. Anyway, judge says to me, I can't hear this case. When's your client going to be back on U.S. soil? What do you mean? She goes, well, they changed the rules. I'm not allowed to consider to hear this case because your client has to be in U.S. soil. They have to come back here. So you're telling me I've got to have my client buy an airplane ticket, fly into whatever state, and then appear just because they're in the United States airspace or whatever. Yep, that's what I'm saying. So what we ended up doing was I ended up basically just writing a brief and asking the judge to make a decision on the brief. I mean, that's what my client wanted to do. So I would tell you that if you're abroad, you can find a lawyer who'll take your case. And a couple concerns there would be, can you get medical records in English that can be read by Social Security, or I guess Spanish, English or Spanish? Are you getting ongoing treatment? Do you have something severe enough that's truly disabling? What is the job market there? You're not able to work because you don't have the right kind of visa, or is it because of your medical problem? Let's say you get past all that. Then, if I took your case, you couldn't do a hearing unless you're willing to fly back to the States for a hearing. Unless they change that, that's what the rule is. But I just had it happen to me this month, so it's a crazy rule. Dimple says hello from Ohio. Hey, Dimple, how are you doing? Deb Lindley, 1947 GMC. Okay. She's responding to 1947 GMC. For EBT or food stamps, SSDI back pay is not considered income. It's a resource. Counted 1 month. Must report this. Okay, so I don't know. I mean, Deb Lindley's always giving good information out, but again, you got to do your own due diligence. Got to do your own due diligence here. A Physique, you've changed your screen name. It used to be something else. TBI survivor, listening in, waiting and applying. My buddy got it for TBI saying, if I work at all, I'm going to be screwed. Can't afford not to work. I think that, again, if you keep your earnings, somebody asked me this today. SGA is $1,690. If you keep your earnings around $1,500, which, less than 20 grand a year, I don't think that's a huge problem. If let's say you earn $1,687 every month, it's going to look like income suppression. So I think that, if you're going to work, you need to be far enough below SGA where it doesn't look like you're intentionally keeping your income numbers down. Judge Bernard was unfavorable judge. Judge Groenveld Megier, same office. My hearing rep is from Kentucky. Some judge retired that was lowest in the country. Open an ABLE account to put excess funds in. Law just changed. Does not affect Medicare. Yeah, I don't know much about ABLE accounts. I think that is something that can be used to protect your money from in an SSI case, but I don't know. Okay. And Charity says, I used AI for mental health conditions, not be considered some potential lawyers. My providers echo their own words. My rep is not okay. It's only hard. yeah, it's hard to get lawyer. That's correct. But I think the AI to summarize your medical will help. I mean, I'll sometimes do that. And again, I use a service that is HIPAA compliant. It's a paid service, but I put all the medical records in there and I'll get summaries. And I find that that's very, very helpful. So yeah. How long are CDRs taken? There's no specific answer to that. It just really depends. I mean, what I'm saying for short form is usually 2-3 months, long form 6 or 8 months. Thank you you're very welcome. You're very welcome. What happens if your representative retires? Well, I think if you're talking about your Social Security representative, you would want that attorney to waive fees and withdraw. It's a Form 1696-SUP 2. That's what you're going to need to get another lawyer, because otherwise it's going to be hard to find another lawyer to take your case. A Physique says there's a lawsuit against nerve stimulators. Yeah, I think I did hear that. So spinal cord stimulators, I suspect I know there was one model that was causing damage to nerves. Maybe it was getting too powerful. I don't remember. But yeah, there have been a couple of them that have been recalled, and there have been a couple that have been subject to a lawsuit. Okay, Jeff Brown says the spinal cord stim blocks the nerve signals going to your brain. Helped a lot until it compromised due to a wreck. Now having to get it replaced. Okay, so Jeff had a good experience with it, and I know some people do. Some people do. But like I said, I find that it tends to work for a while, then it tends to stop. SSA account said I had a hearing with an ALJ May 28th. Check today. It says ALJ has canceled your hearing. It could mean that you're going to get approved on the record. Could be that the ALJ is not available and they're going to put you back in the queue to be assigned to another ALJ. Initial approval at 61. I'm going to get CDR. Probably not at 61. Okay. A lot of discussion between the people here, which is fine. Florida Raider fans says, thank you. You're very welcome. Balance of the back pay, claiming they're holding an SSI overpayment, didn't receive SSI. Yeah, again, this might be where you get your congressperson, your senator involved, because maybe they're operating under false premises about what you were paid. And I think you need somebody to cut through the red tape and get all that information. I will tell you that I had a situation a couple of years ago where I literally went down to the Social Security office to talk to somebody to look at the paperwork for a client of mine. They were not real helpful. I'm just going to tell you. This is where a senator's office can be very helpful, I think. All right, Jennifer says, pay with lump sum or they take it off. They will take it off. They will send me a payment directly. They pay me directly. My pleasure, but yeah, they'll send me make a deposit to me directly. A Physique explaining the close-head injury, traumatic brain injury, exacerbated pre-existing problem, which was not uncommon. SGA, when you have an ALJ hearing, it's just the fifth step. It's can you do any kind of work? Vocational expert and ALJ went through several scenarios, hypotheticals. The VE said you'd be work recluse. I was denied. Realize that the judge asked the VE 5 questions. One of those questions reflects what the judge considers to be your residual functional capacity. That means what is your capacity that is left over after we factor in all the medical problems. So one of those questions, there are 5 questions, one of them reflects what the judge is thinking. A lot of judges will always ask about the off task or about excessive absences. So they don't have to buy that question. They can ask other questions. They just do it to make the claimant feel better or to save time. So obviously the judge took one of those questions, and that's for the basis for the denial. Deb, okay. Talk about the amount of money, what that you paid in. Yeah, there's something called a family max. There's a whole bunch of calculations, but general picture, they're going to pay you what you paid, not more than what you paid in. Yeah, I mean, I believe that you can. There's a pamphlet out there that says, traveling or moving abroad when on SSDI, and it'll explain it to you. I would just go to Google and look for that. Not a problem to travel, but you do need to obviously keep up with your medical treatment. Flynn Howard, I've got a VA rating of 100%, permanent total for mental at 70, both knees at 40 each, 20 for neck and back, 25 wondering what's worth filing. Honestly, the 25 is what would concern me. That's really hard to win at 25. Even if you're at 70%, even 100% disabled isn't going to bind Social Security in any way. I just think that an otherwise healthy person at 25 with some chronic medical issues and some VA ratings, I'm not sure that's a recipe for an approval. So I would probably tell you to keep working as long as you can. This is, not, the odds are not great. You'll find a lawyer to take your case, but realistically, it's going to be a real uphill battle. KU Thunder, good evening. Hello, KU Thunder. Do you think I may be approved? Mark, again, I don't remember what your particular facts were. If I already answered that question, I can't find it, Mark, what your particular problem was. But, I may have already answered what my thought is. It just, I hate to get, when people say, am I going to get approved? The problem is, if I don't look at the medical record, it's kind of hard to tell, because people may tell me, oh, the record says this, the record says that. But, you got to look at the record, because it doesn't always say that. We talked about when the hearing showed up that it disappeared. Okay. Okay. Deb Lindley says, please consider liking, subscribing, and sharing. Yes, please do. Please check that, I guess, the bell to subscribe, and then, or maybe to receive notice of new episodes, and so hit the subscribe button. Yeah, I really appreciate that. I think you'll find this useful, and I will definitely appreciate that, because it does help me grow the channel. I'm trying to do a little bit of that. Let's see. Here's going back to the case evaluation there. Okay. Have a phone hearing tomorrow. Big lyric. Parents are arthritis of the spine, hip and mental health depression. What am I chances? Again, without looking at the medical records, I can't tell you. I don't know how old you are. I don't know how severe the medical is. Can't really answer that question. Wish you the best, but I can't answer it. Fan Cave says, I wish SSA would recognize obstructive sleep apnea as a horrible incurable condition. These other conditions, but yeah, they just, for some reason, sleep apnea, they just sort of see as a mild, somewhat controllable condition. I don't know why, but I've never won a case purely on sleep apnea. No, I don't know anybody who has. I just don't think, I think it's really hard. Okay, I think we've already talked about the cancellation, which may mean you won, or it may mean that they just want to cancel the hearing and postpone it to another date. Okay, this is Deb Lindley answering somebody's question. Charity, haven't worked since 2006 after the big PTSD incident exacerbated my conditions. Wasn't diagnosed with all of them yet. In therapy for 19 years. Yeah, again, SSI is going to be hard to find a lawyer, and PTSD is one of these things where it exists. It can be really, really severe, but it's tough to prove. Very tough to prove. Okay. Been applying since 2016. Wait, people in Congress are multimillionaires, salaries earn $200,000 a year. That is kind of interesting, isn't it? Mostly out of touch. Yeah, I mean, there are some that are in there for the good. I mean, but a lot of them, they get there once they're there for 20 years. How do you stay in touch? You're basically, you have gold-plated healthcare, you have income for life. People are bowing and scraping. Whenever you can speak, you can sign your name on a letter and get free postage. I mean, it's a nice life. You can get it. That's why they like to stay. And if you quit, you can become a lobbyist and make twice the money. But it is interesting how someone who's making 200,000 a year becomes a multimillionaire in 3 or 4 years. It's amazing stock. There have been examples of people that were, trading stocks that had never traded before, making tons of money. Well, obviously there's insider information going on, but that's just part of the corruption. Okay. Uncle Sam says, on the record says, December 10th, 58 years old. I'm not sure if there's a question there or what. About 2 months into recon, we'll have to fill out a function form again. Didn't CE doctor first time. Will you get a CE? It depends on the adjudicator, what they want to do. Will they ask you to fill out a form again? Probably. Yep. Able accounts, and again, I don't know anything about them, so I'm not going to make any comment there. Oh, you're a government representative. You're asking a question. I don't remember what the question was. Charity. I can't find your question. Okay, I'm sorry. I just can't find the question. I got a lot of them in here. What is a caddy waiver? I think this is form. Let's see. Form. Okay, request for waiver. All right, I'll just show you my screen here. Let's get the first page of the form. So you can file an SSA 632. Which is right here, which is called a request for a waiver of overpayment. And you basically give it your information here, explain why the overpayment was not my fault, can't afford it, overpayment is unfair, and you can ask them to waive it, partial or full. They don't have to, but that's a good first step. Then the other form is a 634, where you're asking for a payment plan, basically. Do I know if posting political content online on Facebook triggers reviews? If you don't support the current administration or post videos that question the elites, thanks. I've never heard that. That being said, if I was on disability, I would probably keep my head down. Look, I'll give you an example. This happened years and years ago. Not exactly on point, but I'll tell you what happened. I had a client who had been in the federal government in a fairly, I don't know how I'm going to put this, a fairly public position, and one where he was interacting with a lot of people. And there were a lot of people that did what he did. It was kind of like a community. I'll just put it that way. There was like people that did the same sort of work as this gentleman did, and they all kind of felt like it's sort of us against the world, federal government employees. And he decided at one point that he felt that the people that they were dealing with, which was a certain demographic, okay, were not getting a fair shake. And so he became very outspoken against his agency. He wrote letters. He testified before Congress. He had a blog. He was very outspoken that his agency was treating people unfairly. He came to me and applied for disability. He had some PTSD issues because of some of the flack he faced after going public with his position, and he had some other medical problems and things like that. Got him approved. Well, somebody found out about it in his former agency, and they were not real happy about it. And they wrote a letter to the Office of Inspector General and said, this gentleman is doing work. He was, posting on a blog. He was doing videos. He was doing all this kind of stuff. They're saying, I don't know what he was approved for, but he's doing all these things. And he's giving speeches, and he's this, that, and the other. And they reviewed him and they cut him off. They actually had another hearing, and the judge says, what are you doing? All these things. And he tried to deny it. It was my brother. It was my this. I'm not doing the blog. But judge didn't buy any of it and cut him off. My point is simply that if you are, on disability and you're concerned about reviews, and you know that there's no privacy, and you know that, things that you say or do maybe are going to be, identified by one of the parties or somebody in government, I would tell you keep a low profile. You may feel that's, that who am I to tell you not to engage in your civic right to protest or to, argue your position. I'm not going to tell you you can't do it. I'm just saying, if you believe that, you could be targeted because of your political beliefs, then I would tell you to keep a low profile. What's more important to you? Keeping the money flowing or, arguing your position. And it's hard because, if you're passionate about something and you want to let people know or be out there supporting them, do you make yourself a public figure and then, run the risk that somebody makes a phone call? I've not seen anything specifically that says that there's retaliation, but, nowadays it's not real hard to find out who people are and what's going on. So anyway, enough said about that. I don't know, it sounds so conspiratorial, but, I've always been a big believer in just, keeping a fairly low profile, nobody's business. What you do, where your money comes from, if you're on disability, it's just really nobody's business. And, there's nosy neighbors, there's vindictive ex-spouses, there's vindictive ex-employees or friends, ex-friends. Why deal with it? Just keep your head down. Charity says, thank you so much. Yes, my pleasure. Big Lyric is 44. Again, I don't have enough information to tell you whether you're going to win or not. Sleep apnea. This is the fellow with sleep apnea. I kind of think the day before is a little late, but it's not the end of the world. Again, you want to focus on the things like I talked about with the central sleep apnea, the things that impact your functioning. What are those things? And really focus on those. Okay, good question. When do you get your student loans forgiven? Let's see if I can give you some information about that. Student loan discharge for SSD disability. There's something called the total permanent disability discharge. And let me send you the link here. Just follow this link. And fill out the form and see what happens. That's all you can do. Okay, my first review is 3 or 4 years after approval. Just passed the CDR 3 months ago. Is it likely my second review will be more than 2 years out? Probably more than 2 years, yeah. I would think it's probably going to be another 3 or 4 years at least. Okay, so Mark says, doctors say you shouldn't drive. Let me close this here. Stay in bed, sleep studies. Central. Again, this is what the doctors, this is the medical part. What is the practical part? Well, I'm saying I've never won one with sleep apnea as the primary issue. And generally what I see is obstructive sleep apnea, not central sleep apnea. So I just think that you're going to need, a doctor sort of translate the medical into vocational limitations. Maybe there's something else going on as well. And so, I think if you've got an argument that this is so, and just stop for a minute and think about why you wouldn't be reliable at a job. If I said to you, Mark, here's a job, you're sitting at a table, you're putting ink pens in a box, 8 hours a day, 5 days a week. You got a pen, you stick it in a box. Got a pen, stick it in a box. Why couldn't you do that? What would happen? Would you fall asleep on the job? Would you not be able to come in some days? Can you get that documented? That's the trick of all this. Okay. Well, realize, aphysique, Social Security is now national because the hearings are done by phone or video. So I practice all over. I do cases in Florida all the time. I do cases in New York, Florida, California, Arizona. It doesn't matter. I'm national because most attorneys are do this because it's all done virtually now. Randy Cook. How about low vision, 63, working job for 40 years? I think the long work history is definitely helpful. Low vision, you're going to need to really look at the listing and the listing for visual acuity. I think we talked about this last week. If I'm not mistaken, is listing 2. So I'll put the link in the comment section. So you want to look at listing 2 and ask your doctor to talk about whether you meet that listing. And that's the best way to win a vision case, I think. I'm at step 3 of the DDS Central Daily Living Form. I personally don't because I don't know. I mean, it's your life. I mean, you know what you do during the day. I'll review it, but I don't fill out forms. I think they're evidence. My opinion is I can't create evidence. I mean, if I fill out a form and I get information wrong, how would I know what your activities of daily living are? So I think that that's something you really need to do. Your lawyer can look at it, but I don't think your lawyer should be filling it out. The waiver is national, aphysique. Waiver is national. It's not just Florida. Lost to HOTS. 47, filed for SSDI online 2 months ago. Should I hire an attorney now and paperwork or do it myself? I would wait. I mean, you already filed the application. Honestly, wait and see what happens. If you get denied and need to file recon, talk to a lawyer at that point. I mean, recon, the odds of approval are not great. Certainly by hearing, I would, but many people, like I get hired a lot by people after their initial denial, and then they hire me to do the recon. But you could do the recon yourself. It's a 1-page form. So, like I said, when I'm hired, I can access the file electronically. I can see what's going on. That can be a little bit helpful. But I think at this point, I would wait for a decision. You've already applied. No reason to get a lawyer right now. There's not much a lawyer can do for you. As long as you make sure you've given Social Security the names and addresses of all your medical providers. That's the real key here. Okay, Deb is offering some good information to Mark. Okay, how long should it take to hear from my hearing with Judge Dale? Attorney congratulated me after we think we won. Didn't question the V except the RFC. Yeah, Judge Dale is a very good judge. I had him a couple weeks ago. I've had him several times. He's a very reasonable, pleasant, compassionate guy, and I think that he wants to do the right thing. So it's not him that's causing a delay. It's the writers. So it could be 3-6 weeks. But he was a good judge. You met the grid. Yeah, he's a good man. He's a good judge. Okay. Charity's government rep who asked for the claim. Yeah, I mean, it's hard to assume that people that work for Social Security are the right people to give you advice about a claim because they don't really deal with that much of it, and that person's retired. You're probably better off getting somebody who's in the field, whether it's a non-attorney rep. Go to NADR, N-A-D-R, I think it's .org. There's a lot of non-attorney reps at NADR who might take SSI cases, or NOSCR, NOSSCR.org. That may be another place to go. But might check Nader and see what they've got, because you may find more non-attorney reps will handle SSI cases. Wish you'd hire me early on. Does it as you're thinking you need an attorney? Yeah, please. Thank you. Thank you very much for that. I really appreciate that. And I'm glad you got a good result. Judge Dale, great, good, really good. When I get him on a case, I know I'm going to get a fair hearing. Don't always win, but I know I'm going to have a fair hearing. That's what you want. Win most of them, but not everyone. If somebody waits till they get a denial, I mean, again, it's up to you. I mean, if you already filed your application, wait and get your denial. And then you can either hire a lawyer to do the recon for you, or do the recon yourself and then hire a lawyer to do the hearing. I kind of like to get involved at recon, because that way I can make sure that, because I'll tell you what I do. I'll tell you exactly what I do. And you can do the same thing. No real secrets here. We have a process in our office where we continuously communicate with the adjudicator. We need to get these updated medical records. We fax them, we email them, whatever we have to do. Let them do the work. Let them get all the medical records. And so if I get involved to do the recon, I can get that file put together by having them do it. The thing that you run into if you do it on your own and the file's not put together, now you're at the hearing stage. You get a lawyer, now your lawyer's got to go back and try to get all those medical records in. It can be difficult. It can be expensive to you if he's got to pay for them. Whereas if you did it at recon, it's done for free by Social Security. I'd say that's one reason. The second thing is I can see what's going on, so I know things are delayed. I can say, contact your congressperson. It just gives me a little more, a little more ammunition, I think, to work on a case. But I have plenty of people that hire me. I have people that hire me. I've got one coming up, a hearing coming up. Person has a hearing date and they hired me. So that happens too. I don't like that, but they'll do it. I can get prepared. It's just that the file is usually a mess, is the problem. Does the person who now has his seat, okay, that was the question about your situation. Yeah, I mean, again, if you're dealing with somebody in Social Security and they retire, the person that replaced them, are they going to be able to be the same help? Probably not. They're not going to know. Yeah, so that's Lucky Southern. Yeah, that's kind of my thought. I mean, I wouldn't go quite that far. But yeah, I mean, realize when you make comments online, Facebook, Twitter, whatever, most of the time you're talking to echo chamber people that follow you, that believe what you believe. And it may make you feel good about getting your word out there, but is it going to really change anything? And again, I realize that it's very American to protest thing. I know we're having this whole thing in Minnesota. People are protesting ICE, pro or con or whatever. I just think that if you're getting government benefits and you're concerned that you may be retaliated against because of your positions, it's not. I hate to say, that you shouldn't exercise your right to free speech, but got to make a decision. I filed for SSI and SSDI. I filed for this in October of 23. If they go back all the way back, yeah, they would pay you for SSI for up to 5 months, then SSDI. SSDI offsets SSI. So you're not going to get, double dip. If that's what you're asking. Oh, not sure why my throat's so dry. Actually, when it gets cold, we actually have had to use a humidifier at night because it gets so dry in my house. Okay, got a message that, okay, all right, Charles, I think somebody reached out to you on that. I'm not sure what the incomplete part was. I think Christy is working on that, but I'll definitely, because I've got my notes, got your name sitting right here. I told her to check. She was sick. My paralegal, Christy, was sick a couple of days this week, but I'll make sure that we follow up on that because we don't want it incomplete. But I've got it sitting on my desk right here. Your name. Okay. Okay, easy call. I don't know what that means, but okay. Sounds good. Yeah, if you take getting short-term disability, There'll probably be no offset from Social Security, but you'll have to probably repay your disability, long-term disability character or carrier. Okay, we're getting close to 2 hours here, so I'm going to take a couple more. Okay, Charity lives in Minneapolis, not been quiet what's happening. It's inhumane what's happening here. Again, I think that if you go in the look, I mean, it's unfortunate that anybody who wants to protest something they think is wrong should feel that their life is at risk. Even there's a conservative commentator here in Atlanta who said, Eric Erickson, who's syndicated elsewhere, I know he's on the radio, and he's conservative. He goes, I saw that video. He goes, it was wrong. It was wrong. He goes, and I know there's some questions about the guy's gun, whether it was, it went off and that somebody at ICE thought he was being shot at or whatever. But yeah, you're a federal law enforcement of whatever you're doing. You can't start shooting people. That's a bit of a problem. So I hear you. Okay. Mark says, thank you for your advice. My pleasure. Good evening. If you get your back paid, you have to spend. No, just try to put some away for down the road. Thank you much about Judge Dale. Yes, he is kind and fair. He very much is. Can you hire a lawyer to replace your free rep? Yes, you can. Okay, and this will be, do you think Social Security's affect immigration? I don't think so. I think it's two different agencies. Okay, my wife received 454 BK form. Isn't that the CDR, I think? SSA 454. This will be my last question. That's the CDR form. Yes and no questions. Were not work related, caused by yeah. That's what you would put, because it's not. They're looking to see is there workers' comp here is what they're getting at, but they just wanted. You're saying it's not, and that's what you want to say. Okay, I'm going to leave it there. We are at 2 hours. So again, everybody, thank you very much for tuning in. I had a nice crowd tonight. Some really good questions, some really smart questions. I appreciate it. I think I'm going to have a guest. I'm supposed to have Spencer Bishens on tonight, but he couldn't come. I think next week I've got, if I'm not mistaken, I have, let's see, I got somebody coming next week. Let's see who it is. And I don't know if I've got that here, so I don't want to say. All right, I will put that out there when I know. But I think I've got a guest next week. So anyway, hope you all tune in next week. Hope everybody has a really good, safe weekend. Stay warm. It's going to be really cold out there in a lot of part of the country. Just take care of yourselves and be careful out there, because it's kind of dangerous when you get this kind of cold weather. So I'll see you all next week, and I hope you all have a great rest of your evening and great next week, and see you next Wednesday. Take care. Bye-bye.